I'm here to talk today about the 5 most common myths regarding estate administration. So, I hear a lot from my clients that they don't need an estate plan because either they're too young or they don't have enough money or they don't have any children or a home or real estate. And then they'll say, but I do need a will, a power of attorney, and a medical power of attorney. Those 3 documents are often the core of any estate plan. And for a lot of our clients, that's all that they need to protect themselves and their loved ones for the future. In this host of reasons that I sometimes hear folks haven't done their estate plan yet, I often hear some myths that I wanted to bust today. And the first is that you don't need a power of attorney if you're married. So, this notion that you are married, you are legally married, and your spouse can access your assets and make financial and legal decisions on your behalf by mere proxy of being married. And that is our first myth. Being married does not allow you to access your spouse's individual bank accounts or to make legal and financial decisions on their behalf. So, how do we rectify that situation? Each spouse creates a power of attorney that may name their other spouse to act as their agent in the event that they no longer have capacity to make decisions for themselves or for any reason. Most of our powers of attorney, if not all of them, are created to become effective immediately and don't rely on incapacity. The next myth that I always hear from clients is, well, it doesn't matter if I have a will because my oldest son or my oldest daughter will automatically have the right to be my personal representative or executor, depending on which jurisdiction you live in. And again, that's our myth number 2. The laws of intestacy that are present and take effect when you haven't created your own last will and testament do not place any priority on birth order or quality of relationship. So I get calls all the time from clients who say, my mom passed away and she didn't have a chance to write a last will and testament, and I inherit everything, right? Because I've been taking care of her, right? And I want to say to them, yes, you've taken good care of your parents or your mom, and of course you should be the person that inherits everything. And then I ask them about their siblings. And there's a sibling that hasn't talked to their mom, or 2 siblings that haven't talked to their mom in several years. And the quality of the relationship does not impact how an estate is distributed or who has priority to serve on behalf of the estate. So unfortunately, if you don't create a valid last will and testament, then the laws of intestacy treat your children equally. And no quality of relationship or birth order will dictate if someone gets more or less after you're gone. The next myth I wanted to discuss is the idea that if you pass away, your spouse will inherit all of your assets. And in many of the jurisdictions that we practice in DC, Maryland, Virginia, New York, and Florida, that's not the case. In many jurisdictions where an individual dies without a last will and testament, but they are married at the time of their death and they have children, often the spouse will split the inheritance to some ratio, and it depends again on the jurisdiction, with the children. Where that becomes particularly difficult is in the event that those children are minors, because now not only is the spouse splitting the inheritance, but a guardianship or conservatorship proceeding is necessary to access the portion of the inheritance that's going to the minor children, further restricting the spouse's ability to use those assets to care for the children. The worst case scenario of this I have seen is where the only asset that was part of an estate is a house, and now a parent who is responsible for paying the mortgage is paying the mortgage but only owns a portion of the house, and the guardianship for the minor child, and then eventually the child will own the remaining portion of the house. The fourth myth that I often hear from potential clients or just sort of out there as far as information is that a revocable living trust or a trust will save you taxes. And while there are multiple kinds of trusts, some of which do save taxes, a revocable living trust, which is often incorporated into an estate plan to avoid probate, does not on its face save on taxes. So there is an opportunity for us to build some tax saving language into a trust, but the revocable living trust is not always a tax saving document without that additional language included. And the final myth, which I alluded to in the beginning of my talk today, is the idea that you have to hit a certain age or threshold of money or family dynamic in order to do some estate planning. There is no one that I have met from age 18 on that couldn't benefit from some level of estate planning. So if you're listening to me today and you don't have updated powers of attorney or medical powers of attorney or wills, note that you might be making it hard or impossible for anyone to care for you in the event that something happens to you, or worst case scenario, something catastrophic happens and you're unable to leave your own wishes in your last will and testament. These are just a few of the myths that I've heard that I wanted to dispel today. If you have any questions about anything that we discussed or I discussed today, feel free to reach out. Otherwise, have a great day.